Oyez, oyez, oyez. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning and welcome to the 4th Court of Appeals. Due to the pandemic, we are conducting oral arguments using Zoom conferencing and streaming live to the court's YouTube channel. Because of the nature of the proceedings, we may experience technical difficulties, which may disrupt the proceedings. If this happens, I will stop the clock while our IT specialist works to resolve the issue. If it becomes necessary to temporarily suspend the proceedings, the court will recess and we will resume as soon as the technical difficulties are resolved. When we resume, counsel will resume with the allotted time remaining when we recessed. You will each have 20 minutes to make your respective oral arguments, and then counsel for appellant will have 10 minutes for rebuttal. If a justice wishes to ask a question, she will raise her hand or politely interject a question. At this time, I'm going to take announcements. The court calls Appeal number 0420349 CV, City of Fredricksburg versus E.290 Owners Coalition. Is the appellant ready?
Your Honor, the appellant is ready. My name is Frederick Fritz Quast. I'm here on behalf of the City of Fredericksburg, Texas.
Do I have an announcement from the appellee?
Yes, Your Honor. Christopher Weber for the appellee, and we're ready, Your Honor.
Very well. You may proceed, Mr. Quast.
I thank the court for giving me some time today to present these arguments. I'd say happy tax day, but that's not going to be until June 15th, happily. And first I want to apologize for something. I told Judge Patil this last June when we had our jurisdiction hearing. I'm going to try to make this as fun as possible, but let's be honest, annexation law is not very, it's not salacious or, it doesn't, but, thankfully, if this is your first annexation case, it's likely going to be your last annexation case because in 2019, the legislature truncated cities' ability to do involuntary annexations. But I know y'all have read the briefs and are well prepared, but essentially the crux of the argument over essentially all of the 6 issues presented is the trial court issued a temporary restraining order after the city conducted its first public hearing. Mr. Weber filed suit, and the TRO was issued, and later a temporary injunction was issued, which essentially kept the city from doing anything else to proceed with annexation. There's been no annexation ordinance adopted as of yet. And the overarching theme in this appeal, at least from our perspective, is Mr. Weber and his clients should have let the legislative process run its course. Just because the city started the statutory procedures, which are very time specific, and once you start the ball rolling, you can't stop it. Just because those procedures were initiated, that doesn't mean that the city council could have decided that it wasn't going to annex the property or these properties, or probably more realistically, Mr. Weber and his clients assumed that just because we started the public hearing process meant that negotiations for a development agreement were truncated and that all negotiations were off. In my personal experience, these development agreements can be arrived at and executed the day of the scheduled adoption of any annexation ordinance. Mr. Weber and his clients should have let the legislative process run its course, and they should have continued to attempt to negotiate an agreement with the city. So as far as the procedural background, what this is In June of 2018, the city sent a letter, said, we are looking at annexing your property, and under state law, both under current and former state law, 43016, and formerly it was 035. The local government code said if you have property that is subject to an ag exemption or a timber exemption or a wildlife exemption for ad valorem tax purposes, before a city can annex the property, we have to offer a development agreement. Essentially, what that development agreement would do would continue the extraterritorial jurisdiction status of the property in exchange for the property owner's promise not to do any development. And why that's valuable to cities is essentially if an agreement like that is arrived at, the city can act for the purposes of establishing contiguity to annex farther out. We can act like that property is part of the city. So this is a valuable tool. I believe it was enacted back in 2015. And anytime there's an ag exemption on property, cities have to offer these agreements. So that's what happened in this case. We extended, sent a letter and with a proposed development agreement. Some property owners signed development agreements, some property owners did not. I believe those represented by Mr. Weber met with city staff several times, seeking to arrive at some terms. The city attorney in February 2019 sent an email and said, hey, I think these terms will work. They responded in early March with an agreement that they claim mirrors the terms of what was proposed by the city attorney. The city started its public hearing process, and I believe that was on the 1st of April 2019 is when the first public hearing was held. Suit was filed April 12th, 2019, before the second public hearing was held, before any annexation ordinance was adopted. 2 years to the day before today, the trial court granted the TRO, which kept the city from doing any further, taking any further action to annex any of these properties. The city filed a plea of jurisdiction in its answer. The hearing was held in June of last year on the plea. It was denied, and this interlocutory appeal followed. So the first issue I want to deal with is one that I think that can kill this case completely, at least with respect to the annexation challenges, is after this case was presented to the trial court, and I believe it was after the notice of appeal was filed, the Dallas Court of Appeals came out with an opinion, with facts that are essentially almost absolutely identical to the facts in this case as far as timing. And it's the city of Terrell versus Edmonds. The date on that opinion is September the 8th of 2020. And the crux of that opinion is very simple. It's just, look, this case is not ripe because the property owners in that case filed suit before any annexation ordinance was adopted. In that case, I believe the injunction halted the city after their second public hearing. In this case, it was even sooner. It was before our second public hearing. No vote was ever taken on the annexation ordinance, and they couldn't be under state law. I believe I've raised this in the briefs. I raised in the initial brief. The Dallas Court of Appeals kind of couched this in terms of a final decision ripeness argument. And I believe the opening paragraph of my brief sets out the main theme of this appeal, which is, look, they should have let the legislative process take its course, and they did not. And there's nothing to complain about unless and until there's an annexation ordinance. And they certainly can't complain about any regulations that might or might not apply unless the annexation is ever adopted. And we'll get into that. I believe that's issue 3 and 4. Another thing we can look at is the damage claims in this case need to be dismissed. Absolutely. you know, and the first is on the issue of associational standing. There are, of course, 3 elements to that. I don't think there's been a proper allegation under the first element that there must be members. There's no allegation that there's members of this association. There's no allegation that these property owners are members of this association. But I'll concede that that could be fixed on remand with a repleading. And I haven't conclusively established, or nor could I, that there are no members of this association. With respect to the second element, that's not a very demanding requirement. The purposes of the organization have to be germane to the lawsuit. I think they did that in their second amended petition. But the third element of associational standing test is what's at issue here. And essentially it says, that element says the purpose and relief sought requires participation of the individual members, and the courts have consistently held that if you have damage claims, those require participation of the individual members. I've noted in the reply brief, of course, that Mr. Weber cites a number of cases that support our position. There's one case that allowed, out of Fort Worth, an association to assert a claim for damages, but that the facts of that case are very specific. Essentially, it was a association of property owners that were suing a developer because the developer didn't form an HOA and did not, pocketed the homeowners association dues. Court of Appeals held, and I think rightfully so, that the association could recover those funds and spend them appropriately. That's not what we have in this case. We have the damage claims here are essentially saying that once annexed, the city will apply a bunch of regulations. This will diminish the value of the member's property, and it will also, they'll lose profitability. That type of damage claim requires the participation of individual members. The association can't bring that claim on behalf of its members, and those claims should therefore be dismissed.
Mr. Quast?
Yes, ma'am.
Mr. Weber, or the city of Fredericksburg, seemed to think that the damages can be awarded to the coalition. Can you tell us, or can you see any scenario where the damages would not require an individual member by member determination on damages?
I can't think of, I mean, the damage associated, the damages alleged are loss of profitability and loss of value for each individual property. That is a claim that cannot be litigated without the participation of each member. And each damage issue is going to be different. The evidence on each of those issues is going to be different. It's going to be specific to each particular piece of property. And that's highly distinguishable from the Thistle Hill case, which is, the association was trying to recover the homeowners association fees so it could spend it on the subdivision for landscaping or lighting or whatever. So I can't think of a reason. I can't think of a situation to where the individual members wouldn't be required for that kind of damage. So the other main issue with respect to the damages has to do with final decision and failure to exhaust administrative remedies. And essentially, I don't think he very clearly alleges it, but I've assumed that a regulatory takings claim is being brought, essentially alleging that, well, once the property's annexed, they're going to zone my property, and they're also going to apply these design standards that are going to seriously restrict what I can do with my property. It'll reduce the value of my property, and therefore there's a regulatory taking. But I've outlined in the briefs what the merits test would be for a regulatory taking. And whether it's Lucas or Penn Central, it's a very specific type of inquiry that would look at each property and determine, is there value left? How much value is left? How much was the property reduced in value? And essentially, regardless of which test is employed, there's got to be a final decision on what regulations apply, how they apply, can they be avoided, can a variance be granted? And that's generally what the law requires, is you've got to apply for a permit and you've got to be denied at least a variance. Now that's and a very related concept under Texas law is if there's a statute or some other law that allows you to avoid a regulation, you have to try to avoid the regulation before you can bring a takings claim. With respect to zoning, again, no annexation ordinance was ever adopted. Zoning can't apply in the ETJ. There's no zoning. Some proposed zoning was discussed with respect to these properties, but it was never adopted. And again, just because a city zone or annexes property doesn't mean it has to zone the property necessarily. And again, that is another legislative decision that wasn't allowed to occur. So even if, let's say the city annexes the property and puts a specific type of zoning on the property, there's nothing under the law that says the property owner can't say, hey, I'd prefer a different zoning classification. Or even better, there's provision under Fredricksburg zoning ordinance that you can apply for something called a planned unit development zoning, which is, you know, if your property is 3 acres or more, I can essentially sit down with the city and negotiate what the zoning is going to be on my property. It's very flexible. Again, that's not been pursued. And if there's a complaint concerning any physical restrictions like setback and lot size and dimensions or building height, those are type of zoning regulations that can be that are subject to a variance. So you could pursue a variance from the Zoning Board of Adjustment. With respect to the design standards, just because the property might be annexed doesn't mean that the design standards will automatically apply. And essentially, I think I've included in Appendix 2 of my brief a chart from the design standards that essentially lists types of permits and then lists classifications of design standards. And you have to apply for one of those permits before the design standards even kick in. And even if they do kick in, not all of them apply. There's little X's in the boxes that show us, even if you apply with this type of permit, these design standards don't apply. And even if a permit is applied for, there might be a determination that this is just a routine repair or maintenance, and such that the administrative official can decide that the design standards don't apply. So,
if I may interrupt,
absolutely.
so what you're telling us is that this is far from being final.
Absolutely. So whether we're talking about zoning or talking about the design standards, there are 6 to 8 different things that need to happen before the regulations are applied, and we know which regulations applied, and we know how they're going to apply. So under Williamson County and under Mayhew, there's no final decision rightness yet. The takings claims are simply not right. Now, Mr. Weber says, you know, Williamson County was partially overruled in 2019 by a Supreme Court case called Nick. But there are 2 prongs of Williamson County. The first one is a state law remedy requirement. In other words, before you bring a federal takings claim, you have to litigate the case before state court using state law remedies. That was overruled by Nick. The second prong, the final decision rightness prong, was not overruled. And in fact, the Nick case was partially based on the fact that we think Williamson County was properly decided under that final decision prong. In other words, that's the more settled rationale for that decision. So final decision rightness is still a law, and I think it's a good law. Why should we tag the government with a taking when we don't know how, when, or if the regulation will even apply? So if we move to the annexation challenges, essentially all of these challenges have to do with procedural things that the city didn't do. Mainly, they're complaining about the adequacy of the service plan. Under this court's precedent, the Supreme Court precedent, adequacy service plan is a procedural matter that only can be challenged by the Attorney General, District Attorney, or County Attorney in a court of law proceeding. And so there's an argument that's been made that the legislature added 43908 to the annexation chapter in 2017 that confers standing. The only case that's addressed that issue has decided that it doesn't confer standing, it just waives immunity. And those two cases that decide that are cited in my brief. That's Hill versus City of Fair Oaks Ranch out of Amarillo, and the Comanche Peak versus Granbury case out of the Fort Worth Court of Appeals. Essentially, they continue to decide, they continue to apply the procedural authority dichotomy to whether a private party has standing to challenge an annexation ordinance.
Mr. Quast, you're almost out of time, and I've got a couple of questions for you. First, the appellees, or Mr. Weber's clients, seem to want to have both the old law and the new law apply, if I'm not mistaken. So in your opinion, which law applies to this case?
Okay, that is a great question. I even anticipated it. So the question about whether the 2017 or 2019 versions of the annexation law apply has to do with the 2019 version says, hey, as long as you've adopted a resolution directing the city to study a service plan, as long as you adopt that resolution before the effective date of 2019 law, the old law applies. So there is a question in this case, and Mr. Weber has asserted the question of whether the 2019 or 2017 version of the law applies. And of course, if 2019 applies, we're sunk. But again, that is a challenge to the authority of the city to annex property. That is appropriately private standing. But it's a challenge to an ordinance. Again, we're going to come back to the same theme. There's been no annexation ordinance yet. So what would happen if this case is appropriately dismissed or appropriately narrowed is we'd go back down, and if the city wanted to proceed with its annexations, it'd have to start the procedures again. We'd have to offer a development agreement, and then we could proceed. And if a development agreement is entered into, then both the new law and the old law will be satisfied. And Mr. Weber could then use his argument that the new law applies as leverage, but I think that's the appropriate disposition of the suit. Thanks.
I will save my second question when you come back. It really has to do with the judgment. All right, thank you. Mr. Weber, you may proceed. You may proceed, we're ready.
Thank you, Your Honor. May it please the court. I think what's been helpful to me in analyzing this matter, and what I hope is helpful to the court as well, is to do a little bit of a comparison and contrast between the practical differences that have occurred between the old legal schematic and the new one. Under the old one, the municipalities pretty much had unfettered ability to annex, with one exception, and that is they had to be able to demonstrate that they could provide services. Services were the utilities and police protection type things as well. There was no urgency to do any annexation, though, because the cities could wait until they had those services available for the area to be annexed, and then just go ahead and annex them. The property owners under that circumstance had very little, in fact, basically no ability to challenge it. But at least in exchange for the annexation, they were getting those services. And those services were essentially guaranteed. And if the services weren't provided, that did in fact provide a post-annexation remedy to try and set aside that annexation. Under the new schema, there's a bargain for exchange that the legislature and the governor decided to impose instead. It's a completely new set of rules. And so what we had Fredricksburg doing in this particular circumstance is they realized that before the new law took effect, they would not have the ability to provide those services to the area owned by my clients along the eastern portion of Highway 290. And so they had to come up with a different way of making sure that they could annex those areas when they wanted to. So they tried to do it under basically the old law and the new law. We're saying that only the new law should apply in response to your question, Justice Rios. But what the city tried to do here is they tried to say, okay, we're going to be required to do an agreement because we're not going to be able to annex this property before the new law becomes effective. So what we're going to do is go to these owners with an agreement that is completely different than at least what I believe the legislature intended. What the legislature intended for the agreement to say would have been, hey, property owners, we are going to give you these various services by this certain date. And in exchange for the agreement to get these services, to be provided with these utilities and this police service and that kind of thing, we would like for you to enter into an agreement saying you'll allow us to do so. And the property owners then could negotiate the timing of that, the level of the services to be provided, those kinds of things. That's not what happened here. The proposed agreement that the city suggested basically said, we'll agree not to annex you, which of course was something that a layperson would look at and say, wow, great. They're not going to annex me. Where do I sign? But then the city went on to say, we're not going to annex you unless you change something on your property. That's the problem my clients had with this. We met with the city 4 times and we said, well, let's define what that change is, because otherwise, if we plant a rose bush, that's a change to the property and you can annex us. That's not what the legislature intended. Let's talk about the types of changes that we would have to make before the city could say, okay, that's a sufficient change and we can now annex you. And the city started to work with us in that regard, or at least appeared to be willing to do so. And that was I believe, what precipitated the March email that said, here's the terms that we're willing to accept. What I then did was I took an annexation agreement that I previously worked on with the very same city, with the city of Fredricksburg, but for a different subdivision. I participated in the review and drafting of the annexation agreement between the city of Fredricksburg and the Frieden development that is being developed and is part of the annexation of a different annexation that the city of Fredricksburg is undertaking. So I used that agreement as a framework to basically say, okay, here's the terms that you suggested in your March email. I plugged those into the same framework of the annexation agreement that the city had with the Frieden development and thought we should have this resolved. Everybody's going to be happy. But instead, we got an email back from the city deputy manager, I think it was, who basically said, nah, we changed our mind. We're not doing any of that anymore. Instead, we're just going to annex you. Now, the city was not ready to annex this area along 290. It wasn't ready to provide the utility services. It wasn't ready to do that, but it was trying to pressure the owners on Highway 290. And in some respects, they did. When the city said, we're just going to go ahead and annex you anyway, there was a few members of the E.290 coalition that said, oh, I'm out. Let me just sign the non-annexation agreement. And, I'll let the city determine whatever this nebulous change is, and I'll just risk it. But there were a few that didn't just opt out and sign that agreement with the city, and they stuck to the going forward with the lawsuit. One of those gentlemen is a fellow named Michael or Mickey Poole. Mr. Poole is the most visible member of my client coalition. And he's attended the hearings, he's participated in the meetings with the city, that kind of thing. And when the city found out that he was involved and determined that he was one of the members of the coalition, and when Mr. Poole decided to run for city council, all of a sudden, felony charges against Mr. Poole for supposed voter fraud got filed. Well, this is precisely the reason that we brought the action not as individual owners, but instead as by the coalition. And this is something that the United States Supreme Court has said is appropriate under the Bacala. I'm sorry, that's a Texas Supreme Court case, the Bacala decision, the Bay Area Citizens decision referenced in our brief. I do acknowledge that at some point, in order to be able to secure damages, individuals, the individual owners along 290 are going to have to become parties in this matter.
That was my question. So if some of these causes of action that you've pled or that the coalition has pled, and they do require a member by member determination or fact analysis for damages, then would you just bring them in individually, add them to the lawsuit?
Absolutely. And I've done this before, Your Honor, and I've done it actually in cases that have appeared before this court before. And the way I've done this is when you have a group of persons who are concerned about reprisal or retaliation by other persons or governmental entities, they bring the action with the protection of some anonymity that is provided by the unincorporated nonprofit association. Once we get past a threshold determination, which is about where we're at in this matter right now, did the city act in accordance with the law or did it not? If it acted in accordance with the law, then my clients would no longer have a case to go forward with. It would be dismissed either voluntarily by non-suit or by order of the court, and the individuals would not be exposed necessarily, other than the ones who, like Mr. Poole, evidenced their participation. They wouldn't be exposed necessarily to the reprisals or retaliations by, in this case, the city. On the other hand, if the court determines that there is a violation of the law, then the individuals make their appearance in the case because now they're protected by that order. And they say, yes, I'm here and I'm willing to participate in my individual capacity. I've done that.
Okay, what I'm thinking is we have to look at the pleadings at the time the plea to the jurisdiction was filed, correct?
I believe so, but I think the remedy would be to either dismiss if there is no jurisdiction, or in which case the matter's over, or affirm and remand back to the trial court with an order that requires the trial court to bring in the individuals in their individual capacity now that they have been appropriately protected. And I think that's how the Bacala case, the Bay Area Citizens matter, basically would allow for it.
Okay.
And that accomplishes the goals of both sides, I think. It protects the individual participants from retaliation by the governmental entity, but it also makes sure that if damages are to be awarded, they're awarded to persons who are entitled to get them. So I don't think that simply because the parties have not appeared yet is dispositive of the matter. I think it requires a cure, if you will, to be sent back to the court, to the trial court, with an order saying, okay, bring in the individuals, or dismiss.
Do you agree that your breach of contract claim would require individual members to be in the lawsuit?
Absolutely, it would, Your Honor. And once again, the only reason that this matter has been brought under the protection of the UNA is simply to prevent reprisals from the city of Fredricksburg, which, like I say, interestingly, have occurred to the one person who's been visibly apparent in this matter. That felony charge has not been resolved yet. I think it would be interesting if we'd had that resolution at this point. I'm confident that it's going to be dismissed, but I can't necessarily predict what the court's going to do.
What about the challenge to the procedural defects that you're raising in your pleadings? do you have any case law that says that the coalition can bring those? The case law that we have seen says that that's for, an attorney general or a district attorney or county attorney to bring these types of cases.
I'm glad you asked that. It puts us in a unique sort of catch-22 position. If the law seems to be that you cannot bring an action to challenge the annexation until it occurs. But at the same time, once it occurs, the only parties who have standing to bring the action to challenge the annexation is the government, the attorney general, that kind of thing, through a quo warranto proceeding. And then when you look at the Fair Oaks Ranch case that it literally deals with the city that I'm sitting in right now, it was referred to, I believe, the Amarillo Court of Appeals for Disposition. What the law was very clear in that matter is because the owners waited until after the annexation to challenge the city's annexation, the only parties that could bring a case to challenge it post-annexation was through this quo warranto proceeding. So in other words, it's this catch-22. You can't bring it beforehand, but if you wait till afterwards, you can't bring it either unless the government agrees that the government has done something wrong and two different branches of the government decide to fuss at each other. That basically bars access to the courts for the persons who the new law intends to protect, which is the individual property owners. So I would suggest that under the new law, the individual property owners must have the ability to challenge this because, after all, I mean, once again, if you look at it, the new law requires an agreement between the parties. Well, if there's supposed to be an agreement, then that agreement needs to be adjudicated if there's a dispute about it. Under the old law, no agreement was necessary. So it made sense that courts didn't have jurisdiction to evaluate the way that the city did the annexation because the annexation was just done as a matter of right. Here, it's not done as a matter of right. It's done as a matter of a bargain for exchange. A court needs to be able to have the jurisdiction to look to see if that bargain for exchange is being done in a way that is fair and appropriate. Unlike the way that the city tried to do it in this case, and I think this is what offended both judges at trial court level. It would be Judge Williams prior to his retirement, and he granted the TRO and the temporary injunction in this matter. And then Judge Patillo, who replaced Judge Williams, who heard the summary judgments. Both of them, I think, were offended by, first of all, this false or fake contrived agreement that the city tried to get over on the property owners, saying, we won't annex you just so long as you sign here and say that if you change something on your property, we'll annex you then if we feel like it. I think that bothered them because it gave the city the power that the legislation said it was not supposed to have. That agreement also said, or this purported agreement also said, oh, and by the way, you waive any rights you have under new law. That I think was offensive to both judges. And then I think what also offended both of them is that in the newspaper article, which is referred to in the brief and was part of the evidence in the case, the Fredricksburg newspaper, the same assistant city manager that we'd been dealing with in our meetings with the city prior to the lawsuit being filed, he said, yeah, we're trying to beat this new legislation. That's why we're trying to get this annexation done quick-like here, because we know that once the new legislation takes effect, we're not going to be able to do this for a while. We don't want to have to enter into agreements with these property owners. We just want to be able to do whatever we want to do, just like under the old days. So what the city was trying to do is it was trying to preserve its right under the old law, even after the new law applied. It did that by fostering or promoting or proposing a very unfair, contrived agreement. Not an agreement that dealt with services like the legislature clearly intended, but instead an agreement that said, we won't annex you unless you change something, and then we can annex you whenever we feel like it. But they wouldn't define what the change was. And in the meetings, when I asked the city managers, that would allow for you to annex one of my clients' property if they planted a rose bush. I said, we've got to get more specificity as to what this change is. And they refused. That's not what the legislature intended. The legislature intended to allow for a bargain for exchange with regard to the services to be provided, the timing by which those services would be provided, the level of the services to be provided, those types of things. The legislature didn't intend for it to be an agreement that basically was what we learned in law school as being illusory, where one party's not actually held to any kind of ascertainable standard.
Mr. Weber, I'd like to ask you about your pleadings for declaratory and injunctive relief. You've alleged, the coalition claims that it is entitled to money damages for relief under the Uniform Declaratory Judgments Act. Can you tell us what those damages would be or what they are?
Your Honor, at this point, I think those damages would be minimal, but perhaps even negligible, because since the annexation has not taken place, my clients aren't damaged. Under the new law, it specifically allows for attorney's fees. There's a new case that addresses that issue, and that would be the let's see, I think it's there's a 2020 case, and I've just lost track of it here. If I could be permitted after Mr. Quast finishes his brief, I will give the court a cite to the case. But there's a brand new case that specifically references the new law and granted attorney's fees in favor of the city. Under the new law, it says that attorney's fees are collectible by whichever side prevails. And so a determination is going to have to be made here as to which side prevails ultimately, and then a determination as to the reasonableness and necessity of the attorney's fees involved. But clearly that type of remedy or that type of relief couldn't even be contemplated if the individual owners had no right to bring the lawsuit in the first place to enjoin the annexation. So in terms of actual damages, Your Honor, there's going to be very little, especially if the ultimate resolution in this matter is that the city is compelled to comply with the new laws and these supposed agreements that were promulgated are thrown out.
Mr. Weber, can I interrupt you just really quickly because I see you're running out of time?
Of course.
It's my understanding that you want us to consider this case under the new law. What is your response to Mr. Quast's position that the city began or extended the service agreement before this new law was enacted?
I understand your question, Justice Rodriguez. I would propose that the city would need to be able to demonstrate that they had the ability to provide services at the time that the annexation would have taken place if we're going to have the new law apply, because that's what if that's what we're going to have the old law apply, because that's what the old law required. The city could not annex unless they could demonstrate that they had the ability to provide those services. I would suggest that the city did not have the ability to provide services to my clients at the time they started the annexation procedure. And the only reason they did it was to pressure my clients into signing the made up, falsified, hinky annexation agreement. And if they can't provide the services, they ought not to be able to annex under the old statute.
Thank you.
You're almost out of time, and I've got a quick question for you. Assuming, because we've talked about the possibility, and it's your position, Mr. Weber, that you should be allowed to cure and amend your pleadings to bring in the individual plaintiffs. Just assume with me that the court would dismiss this case. Do you think, would that be a dismissal with prejudice, without prejudice, and would your clients be able to, tell me why?
I think it would be a dismissal with prejudice as to the UNA's claims, obviously, but as to the individuals, to the extent that the city would have to begin its annexation procedures all over again, each individual participant would have the ability to defend against them. At the same time, we would need to know whether the old law or the new law applied to these upcoming annexations. And so rather than have to come before the court once again, if the justices could please consider giving us some guidance in that regard, that would be very helpful.
All right. Thank you very much. You are out of time.
Thank you.
Mr. Quoth, you have 10 minutes for rebuttal.
Thank you, Your Honor. I want to start, first of all, with your last question and Mr. Weber's response. This is a jurisdictional challenge. And essentially the grounds we're asserting, standing and rightness, lack of waiver of immunity for the breach of contract claim. Those are all things that I believe any dismissal would be. Again, the crux of our appeal here is that Mr. Weber and his clients pulled the trigger too soon. The dismissal would be, I think, without prejudice, such that we would then go back down, continue negotiations, and if the city decided to annex this property, then a challenge could be brought that you exceeded your annexation authority and there's private standing because the new law applies and you can't involuntarily annex us. Then there would be rightness and there would be standing, but that has not occurred yet. So I believe any dismissal here would be without prejudice. Let's see. I want to briefly discuss, Mr. Weber made the assertion that, you know, I get to keep my individual clients out of this lawsuit for fear of reprisals, et cetera, et cetera. We know who these people are. We sent them letters. Ownership of property is a matter of public record. And we're not seeking here to have the members disclosed through discovery. We're trying to get the damage claims dismissed. And again, those damage claims would be dismissed without prejudice. If the city annexed the property later, and if those regulations are applied, and if they're ripened and a final decision obtained, then they could bring a takings claim against the city. But not yet. See, I'd like to also note that there's a lot of facts that Mr. Weber is discussing that I don't see in the record, and I don't believe that his unsworn testimony, either now or before the trial court, can be evidence. And this is the first time I've ever heard that some assistant city manager truncated negotiations before the public hearings were began. I don't think that's the case factually, and I don't believe that that is in the record at all. And just, I don't think this matters, but this whole thing about Mr. Poole being subject of some sort of a witch hunt, some felony charges have been brought against him for various things. I'll note that the city of Fredricksburg is not the district attorney, and the city of Fredricksburg is certainly not the grand jury. So I don't think that this has anything to do with some official action by the city of Fredricksburg to punish Mr. Poole because he's challenging these annexations. So Mr. Weber also makes, says, I think what he's trying to say is there's this catch-22, and even if we ripen the claim, then we're automatically dismissed. That's not the case. So to challenge an annexation ordinance, we first need an annexation ordinance. That is the ripeness issue with respect to the annexation challenge. And then once we get into court, we have to ask, is there private standing? So a private property owner could go out and recruit the help of the attorney general, the district attorney, the county attorney to bring a quo wanto action. But if not, you only can have private standing when the annexation, the city, by enacting the ordinance, has exceeded its annexation authority. And all of Mr. Weber's challenges, save the one that the new law applies, are procedural in nature, and therefore there's no private standing. And again, even though there's private standing for the allegation that the new law applies, there's no ordinance yet to challenge. So this needs to be dismissed. And essentially the process needs to be allowed to go forward. I'm very hopeful that some sort of agreement can be arrived at such that these issues can be completely avoided. I think that's all I have, and unless the court has any questions.
I don't have any questions. Does the panel have any?
No, thank you so much.
I
Justice,
don't.
I have that case site that I
Oh,
wasn't
yes.
able to locate a few moments ago. It's an
What is that?
unreported decision. It's Kirk versus City of Lubbock, KIRK. And the site is 2020 Westlaw 5581352. And the importance of this decision is that it discusses attorney's fees. Attorney's fees were awarded in favor of the property owners. I'm sorry, in favor of the city against the property owners. But what this decision makes clear is that attorney's fees can be awarded, as the new statute provides. The only way that can happen is if the parties have the ability to go before the court and seek relief.
All right. Thank you very much to both of you. This was a very good oral argument. Your case has been submitted, and I don't think we need anything else from you. Thank you very much.
Thank you.
We're
Thank
in
you, Court.
recess. Yes, thank you.